Hi, welcome to Jus Cogens, the International Law Podcast. This is another great episode in which we are going to talk about the implications of state silence concerning the right to self-defense. We are going to talk about this in a very general sense, but also in the context of counterterrorism. And joining us today is Professor Naz Modirzadeh, who is the founding director of Harvard Law School Program on International Law and Armed Conflict, also known as HLS PILAC. She advises and briefs international humanitarian organizations, United Nations agencies, and governments on issues related to international humanitarian law, IHL, human rights, and counterterrorism regulations relating to humanitarian assistance. Thank you so much, Naz, for being on the podcast.
Thank you for having me. I'm really thrilled to be here.
Great. So let's just get into it. Can you tell a bit about your work in this regard, about the project on state silence and self-defense? What is the connection? What has your program done on this, and how did this whole concept come about?
Absolutely. So at HLS PILAC, we've published a very lengthy, very detailed report looking at the question of self-defense and state silence with a particular focus on Article 51 of the UN Charter. And we've also, alongside that, published a searchable catalog of state Article 51 communications to the United Nations Security Council after we found, and we were a bit surprised to find, that such a resource did not exist at the time that we initiated the research. I'll say a few words about kind of how we got into this project. So since 2016, PILAC has co-hosted a series of so-called international law lunches at missions to the United Nations in New York, co-sponsored with a number of United Nations member states. And the meetings bring together 2 to 3 dozen legal advisors, including from all the permanent members of the Security Council and a number of other states. And we share our academic research. We talk about the issues that we're working on, and we try to better understand what are some of the questions that are in the minds of practitioners, the legal advisors that are in New York and are trying to work through some of the complex questions of international law and practice related to armed conflict. And I was giving a briefing on the question of interpretations of international law on the use of force, and particularly self-defense, relevant to the conflict in Syria. And I was presenting the so-called unable, unwilling debate somewhat as an afterthought. I kind of assumed that everyone knew this debate, everyone knew the scholars that had taken various positions. And I said something to the effect, I presented the legal stakes of the debate and said something to the effect that there were a number of US scholars who seemed to be increasingly suggesting that this idea of unable, unwilling could indeed emerge as a kind of new customary international law of self-defense. And I realized that there were a number of brilliant legal advisors in the audience who looked completely shocked, who had not heard about this debate, were not at all aware that there was this sort of whole issue regarding the so-called unable, unwilling doctrine. I put all of that within quotes, in the United States, and absolutely were not aware that there was any claim being made that this could be a change in the law on the use of force. And I was really surprised and chastened. I realized that despite all my claims to always do the opposite, I had in fact sort of assumed that a debate that was happening in a very particular context, very much an intra-US international law debate, was something that legal advisors and international law practitioners around the world were aware of, including those that didn't typically focus on the question of international law on the use of force. So one was the idea that this debate and its terms and its parameters were actually not clear to many practitioners whose states had an incredibly important stake in understanding this and potentially taking a position on it. Second, in those series of meetings in 2016, a number of practitioners approached me at the end of my briefings on these issues and said, just wondering, how did you get access to the Article 51 reports that you're citing in your presentation? And I said, well, we got them through publicly available sources. And I realized that many of those same practitioners, in fact, did not have regular access to the self-defense communications that were being made to the council. And as we looked into this more, what we've realized, and I can talk about this more later, is that indeed it is quite challenging for member states to identify these communications and to rapidly be able to get their hands on them, particularly when they're dealing with multiple files and are busy with multiple issues that they're addressing. So this was the beginning, and we realized in our conversations with a number of legal advisors, and we had a particularly rich intellectual collaboration with Pablo Arrocha from the Mission of Mexico to the United Nations, along with a number of other Latin American colleagues and legal advisors from around the world. We realized that part of what was playing a really significant role in the claim that certain scholars were making about this supposed shift in international law was the silence of states, was the idea that there were states that, because they were not objecting to claims being made in the Register of Self-Defense, must be acquiescing or must be silently agreeing with those arguments. So that was the genesis of the project.
So I assume there are a lot of sub questions that come to my mind, and most likely to Umar's mind as well, as a consequence of your discussion. So just to sort of break it into parts, can you tell us a bit about sort of reversing back the timeline a bit, can you tell us a bit about sort of the change that we've seen in the self-defense regime, and how it was, when the charter came about, it was more of an interstate concern, and now post 9/11, the regime sort of has begun to shift. So could you shed some light on that, and maybe just as a bit of a briefer for those of our audience who do not know what unable or unwilling is? So if a brief definition, if you could just discuss that.
Absolutely. And I would recommend, there's an enormous amount of writing on this. I would certainly not recommend anyone read all of it. But our report, and I should note here that, of course, my co-authors, Professor Gabriela Bloom and Dustin Lewis, are not here. So I'm speaking very much in my personal view in terms of my own understanding of these issues, but also trying to bring some of the information from the PILAC report to bear. That report does have a number of citations that may be useful to those who want to kind of get a sense of the different positions being taken, but I'll try to briefly encapsulate this. So as you say, Shayana, a major issue here relates to military actions by a state against a non-state actor in a foreign territory, so meaning not on their own state territory, without that territorial host state's consent or without authorization by the Security Council. And there are numerous strands of this debate and the practice underlying it that can be traced back several decades, if not longer. So I want to be clear here that the idea that this is only a 9/11 phenomenon or only a US phenomenon is not correct. We do find precursors and antecedents to this debate, but there's no question that this practice includes a growing number of purported exercises of the right of self-defense against these non-state groups. This part of the self-defense debate has gained particular attention and relevance as more of the states taking military action against these groups also characterize these situations as counterterrorism context. And in my view, that's crucial to understand, is that the counterterrorism lens, the counterterrorism language is playing a really significant role in the way these self-defense claims are being made. And many of these claims to self-defense assert that the territorial host state is, quote, unable or unwilling to obviate the threat posed by the non-state actor. So in essence, the argument or the idea is that if there are two prongs to self-defense, necessity and proportionality, that if a territorial host state is unable or unwilling to quash, deal with, obviate the threat emanating from their territory, that either satisfies or makes up a large amount of the necessity prong of the claim of self-defense, that it becomes more necessary for the state to intervene, to use force in self-defense because of that very inability or unwillingness. I should note here, there's a lot of good scholarship on the question of consent. There's a lot of good scholarship on the origins of this doctrine itself, but hopefully that's a sort of useful encapsulation. Post 9/11, I think it's fair to say this is an approach that has been tested, honed, re-articulated by the United States. But once we had the advent of the Islamic State in Syria, we've certainly seen a handful of US allies and states that joined in the anti-ISIS coalition also parroting this language of unable or unwilling in their Article 51 communications.
So this, I think, brings sort of the discussion back to your paper as well. And I was reading this article on Lawfare blog, and we'll link it down in the description below as well. That article sort of attempted to map out the states that were in favor of this doctrine, and there were some states which were in objection. And the number of states there were particularly not sort of, to put it in legal language, were not up to the widespread mark of the International Court of Justice's decision in the North Sea Continental Shelf case. So then there is that lacuna or a vacuum in between where we see a number of states that do not react to such positions. So sort of just jumping into the question of silence. So first, can you tell us, before we go into the specific context of self-defense, can you tell us how international law deals generally with silence of states in situations?
Yeah, thanks so much, Shannon. It's a great question and certainly a complicated one. And I'll try to do my best to do it justice. Although I do want to note that there's some really good work being done by a number of scholars focusing on state silence more generally. So Professor Danai Azaria has recently received a wonderful grant working on state silence across a number of substantive areas of international law. Paulina Starsky has some really exciting work in this area. Luca Ferro and Elizabeth Schweiger are also doing great work here. So I stand on the shoulders of those who have done a really remarkable analytical, doctrinal, and theoretical work on the issue of silence. But let me try to say a few words about the research that we've done on this, and maybe I can also say a word about sort of my own view, seeing this play out in conversation with member states. So silence is definitely a complex phenomenon in international law, and part of the complexity arises because it's necessary to discern which of the many possible meanings of silence are operating in a particular context. So there could be tacit agreement indicated by silence. There could be implied objection. There could be a lack of knowledge at play or a lack of interest. And part of the challenge with silence is it's, of course, difficult to interpret and understand something that is not spoken, right? Is not articulated, and then to try to determine the significance of that thing which is not being expressly articulated. In doctrinal terms, in general, silence can concern a variety of different areas of treaty law, including interpretation, invalidation, fundamental change in circumstances, or customary international law. And of course, when we're talking about self-defense and the Charter, we all know both of these may come into play in complicated ways. So let me say two legal issues that are relevant to self-defense in particular. The first is whether or not silence may play a role in establishing an interpretive agreement of a provision of the Charter, namely Articles 2.4 and 51. So listeners may refer to the great episode on treaty interpretation and the Third Geneva Convention of 1949 for more information about interpretation in general. And I think really a stellar discussion for that purpose. But at least according to the ILC, the International Law Commission, the number of parties that must actively engage in subsequent practice in order to establish an interpretive agreement of a treaty provision in the sense of Article 31 of the VCLT may vary, and silence on the part of one or more parties may constitute acceptance of the subsequent practice when the circumstances call for some reaction. And that's the key language for us here, right? Is what are the circumstances that call for some reaction, and is this material subject to those circumstances? The second issue is whether or not silence may play a role in identifying a rule of customary international law, including the customary law parameters concerning the authors of an armed attack. We all know this is crucial for understanding the law in self-defense, and the content of the requirements of necessity and proportionality in self-defense measures. So again, in the view of the ILC, silence or inaction is capable of pertaining to both elements of CIL, opinio juris and state practice. And silence, in their view, could take on a variety of forms when it comes to how we understand state practice. So it could be a failure to react over time. It could be a state not reacting because it didn't get the sense that their reaction was called for. And there is an understanding that for a reaction to be called for, part of what is relevant is when the practice affects the interests or rights of the state failing or refusing to act. So a state being in a position to react means that the state has knowledge of the practice, that it has sufficient time and ability to act. And where a state did not or could not have been expected to know of a certain practice or hasn't yet had a reasonable time, then inaction cannot be attributed to an acknowledgement that such a practice was permitted or mandated under CIL. So there's a lot at play here in how we understand what is silence. What does silence mean doctrinally in public international law in general? And then in self-defense specifically, how could silence doctrinally play a role either in the treaty law arena or in customary international law?
So first, I apologize to Umar because he has a lot of questions in mind. So I'm just sort of taking the lead for a bit. But just as you were discussing this point on subsequent practice, something came to my mind, which was perhaps more of a question to you as to what your thoughts are. But when the ILC says that there need to be circumstances which warrant sort of a reaction, to paraphrase, we know the use of force is a peremptory norm of international law, and to some extent we can even say, for example, it's an obligation erga omnes. So in circumstances where something might be of such a nature, do you think that it is upon the international community as a whole to react to these situations, or should we take the ILC's words for a very narrow confines in a dispute, which is, let's say, the parties involved in Syria for the context of Syria, or is it then an obligation which is much bigger, which needs sort of the reaction of all states involved?
It's a great question. And for me here, this is personally one of those areas where I'm fascinated to see the differences between the debates we have in the pages of journals and then how these debates play out amongst legal practitioners representing states in the world. Not that the journal pages aren't real, but it's just sometimes a very different debate. So my sense is that one of the early reactions that I heard frequently when we would discuss this issue with member states was member state legal advisors responding by saying, this is a Jus Cogens rule, right? There is no, what are you talking about, customary international law and interpretation? That's not even relevant. You cannot change this rule through just normal changes in customary international law. And it does not require a reaction from a state in order to affirm the existence of a Jus Cogens norm. There may be other obligations that are implied when you witness or are aware of a violation of a Jus Cogens norm, but it doesn't require our state every time someone decides to violate a Jus Cogens norm to say, we just wanted to say we object to that and we therefore hold on to this rule's existence. On the other side, I think you have states saying, really, if this was so obviously unlawful, if it was so obviously problematic and so clearly against international law, why isn't everyone jumping up and down and screaming about how unlawful it is? That seems strange. And you have to grant that that argument has some power, right? The idea that if some of the few scholars amongst us who still continue to get upset about this issue are correct about the apparently obvious unlawfulness or even the status of the norm here, you would think that there would be a clamor every day about this kind of violation. So I think this is, personally, my sense is the status of the norm is in a way not a satisfying enough answer to the question. Because no matter what, in reality, what we're seeing is that the underlying legal norms that are relevant here. So necessity, what does that mean? Proportionality, what does that mean as relevant to self-defense? Armed attack, who can be the author? What's the timing? Reporting to the Security Council, all those issues, even if you really hold on to the idea that 2451 comprise a kind of Jus Cogens norm together, it's very difficult to argue that the underlying understanding and interpretation of those very relevant terms are themselves also clearer Jus Cogens rules. I think it's very challenging to deny that there aren't debates and uncertainties regarding some of those terms. And in a sense, my view is that that's where a lot of this is playing out.
Yeah, I was just enjoying this so much. I let Shayan ask all his questions. And secondly, I'm flattered that you listened to the previous episode on treaty interpretation. So I was just, in that separate zone, I forgot about what was happening. And thirdly, coming to, something that you mentioned earlier, but also at a more macro level, I want to understand why state silence actually happens and why states don't participate in the debate. As you mentioned in your briefing to the UN Security Council in the Area Formula open meeting, that lack of access to relevant information is one of the reasons why states choose not to openly voice their concerns and opinions within this context. So my first question of this two-pronged question is, what are the major reasons for state silence? And secondly, why is state silence problematic in and of itself?
Yeah, thanks so much. So I think I'll take the second one first, if that's okay. So I don't think it would be appropriate to say that state silence is always problematic. And a number of smaller states pointed out to me in various discussions, it would be impossible for us to be aware of all of the relevant international law questions happening in the world at any time where we would need to speak, right? We just don't have that kind of human power when it comes to our legal advisors. And I think that's surely correct, that there are some areas where silence may be silent because a state just doesn't have the resources to be cognizant of developments across all the many areas of international law. But when it comes to self-defense, I think silence comes with a cost. Not developing a view on a legal debate and not participating in that legal debate when it comes to this issue comes with a cost. One, it contributes to normative uncertainty. And I say that I recognize and I deeply understand the frustration of those who say, Naz, every time you say that, you play into the hands of those who are seeking to create that very uncertainty by introducing these innovative notions of international law. Why not keep saying there is no uncertainty, the law is crystal clear, this is illegal? I'm very sympathetic to that argument. However, power is real and it's in the world. And I think we know that there is a difference in the force and the political significance of certain international legal arguments, depending on who makes them, in what context they are made, and if they are made, if you will, on the back of missiles, right? I mean, there's just a difference in how that, what that means in the real lived experience of international law. And so I think that their silence, legitimately or not, can be understood or can be portrayed as a tacit support for claims in the register of self-defense. And at the very least, I think all member states need to be aware that their silence could be utilized or even manipulated in that way. If they choose to remain silent, of course, that is their choice. But I think the idea that is problematic is if they are unaware that these highly significant debates are taking place and that they have a voice in those debates, even if they do not participate militarily or otherwise in any of the counterterrorism operations in question.
So just taking this forward, one of the problems that I see is with regards to Article 51 and sort of the obligation to report questions of or report instances of self-defense that all states are mandated to do. So in practice, we see that this is not very often followed. So can you tell us why states are, even though that would sort of, as the court also said in 1986 in the Nicaragua case, it would sort of solidify the position that an act or a certain act was carried out in self-defense. So in those situations, why is there a reluctance on states or on part of the states to report actions in self-defense when they obviously have the opportunity to do so before the UN?
So I think that it is clear in the research, and it's clear in looking at communications to the Security Council, that states seem to respond in any way, in opposition, in support, to these self-defense communications relatively infrequently and irregularly. So the Security Council very rarely is conducting meetings in order to discuss these self-defense communications. And states individually are also not very frequently responding to these communications. And in a way, I think this connects to Omar's earlier question, the prong that I did not answer, which is why. I think there could be many reasons for why that have nothing to do with international law. It could be that a state concludes that it is unwise to speak on an issue such as this. It could determine that it has other interests that would be put at risk if it were to speak on this issue. And it could determine that in the balance of its interests at the multilateral level or at the global level, taking a principled position on international law that doesn't directly concern the state in question is simply a luxury that state does not have the ability to afford. So I think it is relevant that there could be all kinds of explanations that are not legally salient at all and have nothing to do, we can't read international legal intention into them. I think, though, there's still a mystery here, which is even if we sort of count up all of those reasons and we discount for all of those reasons, why is it that states aren't engaging more on this topic? Why is it that states aren't, they don't seem to think that this is an issue that it is critical for them to clarify and articulate their positions on? And I think the ARIA formula meeting that Omar referred to earlier, hosted by the Mission of Mexico to the United Nations, is a step in a different direction, right? So it is this attempt to say, one, we need to understand these arguments and these issues. Two, it's important for states to think about their own views as to those issues. And three, it's important for them to consider whether or not their silence is intentional and whether they wish for their silence to be read as legally salient. So one interesting move that's, I think, a few states have made is to say, we do not believe that silence can contribute to customary international law in the area of self-defense, right? That's one way to go, is to just put that out there. So don't read my silence as anything. But I think this is perhaps, and I say this only perhaps because I think the research on this, we need more research on this, but I wonder if we could read this as being part of a larger trend away from clear statements of opinio juris, that states, for whatever set of reasons, are more and more careful, more and more reserved or reticent about speaking clearly in the Register of International Law, speaking clearly and saying, this is our view on this disputed or complicated or developing question. And we could read that all kinds of ways politically, right? So there, I think it depends on what perspective you have here. But I worry that it plays into the hands of those states that do wish to argue that there are quickly emerging customary international law rules that cut in their favor. So I think that this is just an area where it may be a good moment for states to think about whether it's time to start participating more, to start speaking more clearly, to start thinking about where are those areas of international law where we want our voice to be heard, even if we can't identify an immediate, tangible national interest on this issue.
Right. Thank you for that explanation. I want to prod you further a bit about the concept of normative uncertainty that you briefly talked about. And I want to understand how that can potentially lead to the obfuscation of similar issues such as preemptive or anticipatory self-defense that you have also mentioned in that briefing as well. How does this all play out? The concept of normative uncertainty and it potentially leading to certain undesirable consequences in terms of consensus on other controversial or related issues.
That's a great question. I think I sometimes wonder, and this is not only me speaking in my personal capacity, this is not a doctrinal answer. So there is obviously an answer that the three of us could probably very quickly come up with, that is sort of what is normative uncertainty as a doctrinal matter, and how does that how does actual normative uncertainty work in the world? I'm in a way kind of more interested in the argument, the claim of normative uncertainty, right? Where many of us might say, I don't see normative uncertainty there at all. You're making that up, right? It's a move that you're saying it's normatively uncertain, which of course, different states use that argument in different areas for benefit where it is useful to say that the law is uncertain. It's a game we lawyers play in various areas of international law. In other words, I think in the area of the use of force. One, I think that the claim of normative uncertainty has played a critical role since 9/11 in the expansion of counterterrorism. So the idea of, we remember, those of us who are old enough to remember the arguments about the Geneva Conventions being quaint, or the claim that we need a new law for addressing terrorism, right? All of this, it builds on an idea that this situation is so different, it's so terrifying, and it's so historically unprecedented that the law becomes unstable because it cannot address the situation. And so we are scrambling to find answers in the law that we have. And we most of the time find, as it is put it in UN speak, that it is not fit for purpose. So one, I think the claim of normative uncertainty is useful for supporting a mood, which is almost what I think it is, of panic, reactivity, the idea that terrorism in a way undermines all of the things we know and we can hang on to. And therefore, it justifies really sudden reactions because that's all we have. Right? So that's one. Two is, I think the claim of normative uncertainty opens up the possibility that you could make an argument that those who are most affected are the ones that make the rules. So it opens up an argument. Again, I am not claiming this is a doctrinally sound argument, but I think it's an argument that's being made quite frequently between member states and in and around the Security Council. So it's an argument that essentially says, because things are normatively uncertain, those who are the most active in this particular area take the lead in crafting the new rules, in giving us the contours of that uncertainty. Three, I think that an argument or a claim about normative uncertainty can privilege those who have not only, as you might say in sports terms, kind of a deep bench of international lawyers. So those states that have a phalanx of international lawyers that can be assigned to a particular issue or task, but it also privileges, perhaps, those states that have many publicists or scholars, as we would call them in regular English, who can write about these issues in the scholarly arena. So if there's this normative uncertainty and all of a sudden there are 10 major articles on this issue from the perspective of the state that is claiming that normative uncertainty, very quickly the international law conversation can kind of contract to actually being a conversation amongst very few states. You know, I was struck at that ARIA formula meeting. There were about 30 states present, and it felt to me so exciting that we were having this conversation, finally more voices at the table. And then you think 150 plus states are not here, right? There is this way that through language, through the places where there are elite legal institutions, and through the loudest voices, we might forget that a conversation that is occurring on questions of certainty and uncertainty is not actually a conversation that is occurring between a wide array of states. It's a very small slice of the relevant actors that we actually would need in order to determine if a rule is stable, is changing, or needs to be changed.
Quick follow-up. I like that you talked about representation in the latter part of your answer. Yeah, so what I want to know is, how does the existing system of states and the existing power imbalances in global politics and within the UN system itself, how does that further contribute to this existing level of normative uncertainty?
So one is that you may have those states that have an interest in claiming uncertainty may be the same states that dominate the debate, have the most military power, and are in a position to and are in a greater position of power at the Security Council. So it just may be that you have an alignment between the claim of uncertainty, the argument of uncertainty, and the levers of power, if you will, at the multilateral and at the global level. I think also there is almost an attitude of this doesn't concern you that is conveyed to many states around the world. So there is almost an attitude of we are the states that are participating in counterterrorism efforts around the world. We are the states that are funding counterterrorism efforts around the world. And we are the states that are risking our own military personnel and military material in these counterterrorism fights around the world. Those of you who are not don't really need to contribute to determining how to handle this normative uncertainty. Thank you very much, but move on. And I think it's there that it's critical for all states to remember that if indeed the prohibition on the use of force is the cornerstone or a cornerstone of the United Nations Charter, then it means that all states have a real and continuing interest in understanding and engaging in these debates, and should push back on any suggestion, express or implied, that they don't have a place at this table.
I think it's very interesting that you mentioned sort of this pushback by stronger states. So perhaps a counter argument can also be made that they are not the sort of the specially affected states, but those states in whose territory these operations are being carried out, they are perhaps, you know, the specially affected states in that sense. But just to sort of revert back to the question on why states do not come to the Security Council. So can you briefly tell us, for example, state A has acted in self-defense and it wants to report to the Security Council, it will write a letter. What happens then? Where exactly do you see the problems in terms of accessibility and all of these relevant associated concepts? So where does the problem, or where do the problems come about in this whole process, so that, and sort of how these can be improved going down the line?
Yeah, thanks, Shan. So a state communicates, it's Article 51 self-defense communication, if you will, and it has very little guidance, at least as a matter of law, as to what should be in that communication. So there is a question of, for example, how detailed should an Article 51 self-defense communication be? Does the state need to lay out exactly the contours of the armed attack that occurred? Does it need to lay out its arguments in the language of necessity and proportionality? Does it need to cite precedent? Is it kind of a legal memo? Is it satisfactory for a state to say, we are doing X in self-defense, thank you very much? This is one area where I think we need much more discussion and debate amongst states, and we need states to make clear their view on this question. What should be in an Article 51 communication? So I may look at some of the recent communications and say, this can't possibly be good enough for us to be able to evaluate the validity or the legitimacy of this argument of self-defense. But I'm not a state, unfortunately, right? So we need states to be the ones that are doing that. So it files this self-defense communication. And what happens now is that the communication is going to be circulated to all member states as part of the sort of entirety, if you will, of the Security Council's communications overall. So a state that wants to understand what are the Article 51 communications that are being made to the council, first would need to determine what counts as an Article 51 communication, which is not clear. So the council hasn't made that clear. It is not, we don't have an authoritative interpretation of that. And some of them are indeed hard to understand. And then it would need essentially to go through all of the Security Council's communications in order to find those that qualify as Article 51 reports or as Article 51 communications. So this, at this time in 2021, this is likely to be thousands of documents that have an S- document symbol and that are communications with the Security Council, with no way of discerning from within that, unless you really are going to go through and read in order to find it. My experience is that many times the way states are finding out about Article 51 communications is if colleagues send a WhatsApp and say, there was a new Article 51 communication, this state has done it, this is what it is, or they read about it in a blog post when an academic reacts to it. It is rarely because they have a system in place in order to identify these from the council itself. So one kind of seemingly boring logistical procedural question, but I think crucial to this question is, should the Security Council develop a mechanism by which it clearly, predictably, and rapidly communicates, conveys Article 51 communications to all member states when they are made to the council? Right now, the answer to that is no. My sense is that there are now a number of states who think that this is a really important issue of transparency that merits a discussion at the council and, of course, beyond.
So this sort of takes us to the ARIA formula meeting as well. So what were some of the state responses when you sort of tabled these questions to the member states? So what did they have to say? I noticed some of the responses, and I saw this trend where states were very perhaps active in terms of responding to where self-defense is going, but in terms of things which came to the procedural aspects in terms of reporting, they were perhaps not as vocal or didn't have as many suggestions. So what are your thoughts on the meeting and sort of the takeaways from that?
Yeah, so I think one is to say, again, my personal view is it is very difficult to sustain a principled argument that says states outside of the Security Council should not be made aware of Article 51 communications, and that the council does not need, if it is capable of doing so, to make that information readily and easily available to states without them having to wait for the publication of Security Council documents 4 or 5 years after the fact. So you could make an easy, frankly, cheap legal argument to say the Security Council is not obliged to do so. Sure, of course, we could all agree with that. But once there is a demand, I think it's very difficult to have any principled argument that you could say it's not a good idea for the Security Council to do so. And if that argument is made, my response is, why not? Why? These are not classified documents. They're not confidential documents. Why shouldn't states have ready and predictable access to these documents? Second, I think that you're right that states seemed to be responding in a variety of different registers. So I thought that some clearly did not wish to be seen as taking a position on any of the issues that had been presented by Mexico for discussion. And some seemed to want to take positions on, as you say, the substantive legal question of the parameters of self-defense. So either on whether or not there could be an armed attack by a non-state actor, or whether or not there could be a use of force in self-defense against a territorial state that was unable, unwilling. And that was really fascinating, right? So I do think that we had a number of states articulate themselves on this issue for the first time. And I think that is, if you genuinely are interested in this, then you also have to accept that it could be in a variety of directions, right? And three, I think you had some states that for whom this event was an opportunity to better understand and to hear what the debate seemed to be about, hopefully with an eye to developing a considered position over time. In terms of what the positions were, I know that Professor Adel Haq, who is, unlike me, fantastic on Twitter. I know he had a Twitter thread at the time of the event, and he has a post on the Just Security blog where he discusses this issue. There are also some really interesting updates on practice in the Journal of International Law and the Use of Force, and the website of the famous Sievers and Dawes procedure of the UN Security Council also has some information on this. Whether or not all of those states that spoke in that event were ready to articulate positions on this issue, my guess is no. And I think there is, I know that there were some who were disappointed that some states seemed to be avoiding taking a clear position. But overall, I thought it is an excellent start. It is the beginning of something that hopefully gains momentum and continues and becomes an issue of interest to more and more states.
Right. So I hope that this discussion could have gone on longer, but unfortunately we're short on time. And personally, I have thoroughly enjoyed this. So I just want to get your final thoughts on the entire matter, and how do you see the way forward before we end the discussion?
Yeah, thank you so much, Omar and Cheyenne. It really was a pleasure. I think that I don't have any profound final words, but I'll just say that I really do believe that it is crucial for states to have access to the relevant information regarding debates in international law that they would need in order to develop and take positions on these questions, and that it is critical that our debates on these questions of international law and the use of force recognize the many states that we are not hearing from. So those of us who are scholars, those of us who are commentators, those of us who are working on these issues, I have been humbled by participating in this conversation. I have been humbled by talking to legal advisors and other representatives of states who have remarked that it is preposterous to claim to have a debate or even a global debate about an issue as crucial to all states as the prohibition on the use of force, and to not clearly recognize how many states are not playing a role in that conversation. So I think if we can both encourage increased access to information, transparency of the council, more debate and engagement, but also recognize the flaws in our present debate and recognize those who we are not hearing from, I think it will help us to build, hopefully, a better and more vital and dynamic discussion about international law and the use of force in the future.
Perfect. On that note, we'll end the podcast. Thank you so much, Naz Modirzadeh, for being on the show. And I'll see you in the next episode. Thank you.
Thank you.